मन की चाल समझ ली तो सब
There is an adjudication of that 18-2. It's giving judgment at 2 p.m.
Then?
My lord, this is an eviction, but can it be listed tomorrow, man?
No, what is the connection?
Connection, my lord, because notice was given me to me on 18-2 for eviction.
So let us await for the judgment.
Judgment, my lord, is a different issue, my lord, is a reference. My lord, it is
I know it is a reference, but with regard to 18-2.
18-2, my lord, because
whether it is necessary to give a notice or not.
My lord, if by chance if it is not listed, my lord, then my lord, I will be nowhere, my lord.
You make a mention tomorrow, but let the order be placed before the court first.
My lord,
isn't it?
Eviction matter, my lord, because otherwise I will be absolutely, all the shops will be evicted. I will place the judgment tomorrow, my lord. If it goes against me, then I have nothing to say, but only can it be listed, my lord. Your lordship will look into it. There is a civil suit, there is an injunction given. Still, then, my lord, there is a notice for it.
All right. What?
I beg to mention item number 7, Lordship. I want to withdraw this petition, Lordship.
Withdraw?
Yes, Lordship.
You want to withdraw?
Yes, Lordship, with the liberty to avail appropriate remedy under the law.
Your name?
J. Singpho, Lordship.
J. Singpho. Actually, like to withdraw the petition. Liberty to where paid is allowed. Yes.
I am for 1 to 5, Lord. May I please, Lordship, with the consent of other side, Lordship, I beg to mention item number 30 and 31.
30
and 31. Similar matter is coming on 24/7, Lordship. I have taken the consent, Lordship. Let it become on 24/7.
30 and 41.
31.
31.
Yes, sir.
Sorry, 30 and 31.
Yes.
Okay, and
let it come up on 24/7, Lordship. Similar matter.
You have taken consent?
Yes, yes, Lord.
Mr. S.S. Roy, CCC, appearing for the respondent. Submits that 6 matters are listed on 24.
24/7.
07. 2024. According to these two matters, 30 and 31, listed on 24/7, along with
arbitration petition 10 of 2024.
Arbitration petition 10 of 2024.
Obliged.
It's submitted. Consent of the petitioner in person has also been made. This recording. Yes.
Obliged.
May it please your lordship. I want to pray for listing of a writ petition, if possible, tomorrow, my lord.
What
difficulty is the circle officer of the revenue circle, my lord, had issued a notice entering in acting as a civil court, my lord. He is telling me, as per your sale agreement, pay up the money or we'll forfeit and take action against you. We appeared, but he's not budging, my lord. Verbally, he's doing that. Now, since the vacations are ensuing, coercive actions he's taken, I have to challenge that again back. So tomorrow, my lord, I'm praying for that consideration.
No, has he passed an order?
He has not passed an order. He is bullying out, my lord.
Then?
That's what is happening. We have appeared. We have represented to the council. Now he is saying you pay
Why
up.
are you apprehending if he's not passed an
No,
order?
that is what has been told to us. He's not writing it, my lord. Since the vacations are ensuing, just to that action. Let the proceeding continue. No stay, no stay. Let the proceeding continue, no coercive action. Just be fair on whatever notice you give.
Coercive action is a stay.
No, I'm not on that. Let him proceed with that and come to a logical end. But whatever he is submitting will.
What is the idea of filing a preemptive writ petition?
It is not at all a preemptive writ petition. We did not come earlier. We approached there. We said, kindly give us a complaint. Kindly give what is it. We'll comply. We are appearing.
Let him pass an order. Then
My
you come
lordships,
before the court.
since the ensuing vacation is there,
So,
in terms of that, I'm praying for a consideration only. If I'm able to satisfy your lordship.
Consideration of what in a case where there is no order passed?
My lord, this is a case where a circle officer has usurped the jurisdiction and entering into a negotiation with us to pay up, others will take action against you. That's the case.
We'll see.
Obliged, lordship.
May I please, your lord? My lord, I beg to mention regarding item number 8, my lord, that the Zagiru eviction matter, my lord.
Yes.
We have filed an additional affidavit that may kindly be called for, my lord. And secondly, a similar.
When did you file it?
My lord, filed it today, my
Then?
lord. My lord, and the writ petition, similar petition has been filed, my lord, in connection with item number 8, my lord. It is filed today, my lord. My lord, can it be both the petitions be taken up at 2 p.m., my lord?
No.
My lord, some urgency is
No,
there
no.
even after the, my
You
lord.
file it today.
Today,
You
my lord.
file an additional affidavit today and
No,
you
no,
want it at 2 p.m.
No, no, my lord, the, that additional affidavit is, can be called for, but a fresh writ petition has been filed, my lord.
We'll have it tomorrow. Give the list, both the matters. Item number 8,
But my lord, there is an interim order operating till today, my lord.
we can't help it. Let it be tomorrow. Then you should have filed it earlier. Why have you
My
filed
lord,
it today?
is, my lord, lots of document is required to be prepared. I have tried my best.
Can't help it.
Then both. the-
Either you make either you see,
Mal.
vacations are there at the request of the
that
bar,
I can understand.
isn't it?
Mal.
So therefore, you know that there is a vacation ensuing,
My lord.
and you wait to file these
No,
affidavits
no, my lord,
today.
actually what has happened, my lord, the documents which we have been furnished, my lord, it is the, even after my lordship stay order, my lord, they have evicted. My lord,
This matter, item number 8, we can see. All right, we'll take it up. It is already listed. The other matter, we don't know.
then can be tomorrow, my lord.
Yes, tomorrow.
Obliged.
May please your lordship. So with the consent of other side, I beg to mention for item 37, so maybe adjourn for today and may come after
Item 37,
37.
the request of respondent.
respondent number 5.
Respondent 5 submits that with the consent of the counsel for the petitioner, the matter be listed the month of July, 3rd week of July. Matter be listed accordingly and on a date to be fixed by the registry.
May it please the Lord. With the consent of other side, I'd like to mention item number 21, Lordship.
21.
Yes, Lordship.
Yes.
Lordship may take up the matter after vacation.
Item 21 to be listed after 3 weeks at the request of counsel for the
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 5. Honor, the affidavit in opposition has been filed by the respondent in this case yesterday itself. So the same is also not on record. Let the matter be listed soon after the vacation.
Item 5 will be listed after vacation at the request of the counsel. The writ petitioner.
Yes.
Mr. Paridi.
Yes. Much of.
May I please your lordship, I beg to mention for listing of the
But
matter.
have you informed the other side?
Yes.
You have taken consent?
Yes.
Consent of counsel for the respondent. Yes.
Much of.
May I please your lordship, I beg to mention for listing of the matter on tomorrow, your lordship.
What is the matter?
Your
What
lordship,
urgency?
it is the land matter that the police is interfering in the land rights without any order from the court, your lordship, and they have diverted me from my property and they have occupied the property, your lordship.
Our police has occupied your property.
Yeah, police with the help of the land grabber, your lordship.
You go and file a case under the Land Grabbing Act. You go there and file.
Your lordship, it is to be hard because the police along with the land grabbers, they have.
That's
occupied,
right.
your
There is an
lordship.
act called the Land Grabbing Act. There is a forum already established. So you should go and approach that court.
Your lordship, it is a writ petition matter, your lordship. So
Writ petition matter, I know, but you have an alternative remedy. Have you filed the petition?
yeah, yes, lordship.
When?
April, your lordship.
You
The
filed
month
it
of
in April.
Yes, lord.
Why the
It
matter
was an
is
objection, your lordship, so we had rectified it, your lordship.
Silo. Verify. Yes, okay. Subject to verification. Clearance of your defects.
Yes, lordship.
Yes.
Much obliged, your lordship.
Yes.
That's why I mentioned for listing of the WPC, lordship.
Why?
More.
Why?
Like urgency is there.
What is the urgency?
Lordship, in this matter, we have not recovered the security money, lordship.
There is no urgency there. Let it come on its own. Contract matter.
Yes, yes, lord.
Let it come on its own. No urgency. Yes.
My lord, one IA has been filed, my lord. Lordship will find IA number, my lord, 1979/2024.
Yes.
For impleading party respondent number 9. My lord, in view of the, my lord, notification, Lordship will find at page 9. Page 9 of the IA.
Page 9.
Page 9 of the IA 1979.
IA is 1521.
No, that is different IA, my lord. IA 1979. Item 51, my lord. I'm sorry, my lord. Item 51 in the supply. It is taxed with the, my lord, item 1. item 51.
আপনি না জানেন প্রিন্সিপাল সেক্রেটারি কি করা হবে?
Page 9, Lordship will find.
Yes.
My lord, last paragraph, my lord. The statutory powers and administrative powers as exercised by the divisional commissioner at present will henceforth be exercised by the commissioner and secretary as principal secretary of the general administration department. Now the principal secretary general administration department should be made party respondent number 9. Otherwise, my lord, the appeal pending before the
No, Lordship, after this notification was issued, the special secretary.
You are agreed by what?
my lord, we are agreed by the my lord, award
They have
my lord, given by the my lord,
So
law authority.
there is a provision
Yes.
for
There is a provision.
the arbitrator.
Yes, appeal has been filed before the my lord, that authority, my lord.
Is it an appeal or an arbitrator?
No, arbitrator is appointed as
Ah,
special secretary to
Special
the
secretary.
government of Assam.
Now he is the my lord, secretary general administration is the my lord, competent authority as per this
No.
notification.
Appeal filed
Nothing happened.
under what? Under what provision?
My lord.
You have filed an appeal under which provision?
My lord, under section 3G5,
3G5, no?
3G5 of the National Highest Act.
Resettlement.
এটা তো গমেই নাপায়। এইটো দি দিম, আছে আনিছো মই।
Resettlement.
এইটো কৰোঁতে নাপায়।
3G5, my lord.
এটা নাই নেকি? লগাই দিম।
I am sorry, my lord, I have marked the my lord, certain portion.
3G.
3G5.
3G5.
Money.
Is to be the arbitrator.
The arbitrator.
Then why you say appeal?
Now earlier, yes, application.
Application.
Yes, application we have already filed.
Ah.
Now, as per this notification, my lord, the principal secretary is to call on the my lord, said application.
No, it is the special secretary.
Yes, special secretary to the government of
It is the special secretary as per his
As per this notification says,
ওলাইছে।
the
21st February.
divisional commissioner was never given the power.
Yes.
earlier divisional commissioner was the my lord,
No.
Earlier,
You have
earlier.
this notification.
এখন নাই, এখন
1st of
ওলাইছে।
February 2024.
Let them approach before the
It is before the special secretary.
then we have to make.
approach.
I don't know what you have to make, but a divisional commissioner, commissioner and principal secretary is not a necessary part.
Special secretary. my lord.
We don't know. It is for you to apprise yourself. There is a notification here.
Well.
Specifically empowers special secretary to government of Assam as the arbitrator.
Let them approach.
You give him a copy.
I have copy. Hello, look at more আছে।
Yes, I'll make my lord.
Let them approach the before the
No, but why do you want to make him a party? You have to go and approach that
Yes.
authority.
Unless my lord, he is made party, my lord. Already my lord, application has been filed before the my lord, principal secretary.
All right.
Yeah,
Then you withdraw this IA.
Yes, my lord,
IA so and so 1979 is not pressed by the petitioner at this stage at the same. Yes. Then
then my lord, liberty may be given my lord, to make party respondent of the special
you
secretary.
have the liberty.
Eh?
You can make anybody a
Yes.
party.
let them
I'll
approach the
file it.
special secretary.
That will be listed after 4 weeks.
No, what happened, Lordship, they are getting the interim order.
What interim order?
Yes, Lordship, kindly go to the interim order. They unnecessary, they are harassing us. We could not go ahead with our construction work. Interim order.
Interim order is not to demolish the my lord, building unless the
Already,
award is paid.
already 3G award has been declared, Lordship.
Now 3G award has been declared and it is that my
After
lord,
that-
application has been filed before
My
the
interim order should continue, Lordship. Already
You have
3D
filed your application,
application has been filed.
and then
Before the
you
principal
are aggrieved by the quantum, isn't it?
quantum,
You have received a certain amount of,
not yet received, my lord. Only
No.
award has been declared.
that's right.
here.
There is a finding here where it says that you have received some amount.
No, my lord, no amount has been paid.
You can continue.
Not a single amount.
Who is required to pay that amount?
The my lord, Kala, competent authority.
You could-
Who appears for Kala? What is the status?
We have received the instructions. The estimated amount of rupees 84,26,548 only has been forwarded to the General Manager PMU, Bongaigaon NHS DCL, filed letter dated so and so for submission of the draft 3G award to this office. Once the draft 3G award received from NHI DCL, these instructions we have received in the month of March. Thereafter, they have filed their affidavit.
We have
In-
filed an additional affidavit.
No, but has he been paid the amount?
We have deposited the amount
Before whom?
to the Kala Lord.
So
Lordship, may I get a copy of this affidavit so that I can verify and place the same before you?
you are entitled to a copy. You don't have to-
Lordship, the copy was not
Why
served upon us.
don't you serve copies? It's matter of, it's specified in the rules.
It will be, okay.
You are required to serve copies on all councils.
That is why, Lordship. In that
Let
case,
it come
Lordship,
after 4 weeks. You decide amongst yourself when, who is to pay the amount.
Lordship, we have already deposited.
You
but
have deposited, he has
Kala,
not received.
Lordship, if it is deposited, if I get the copy, in that
Yes.
case, I can verify and get
Least
the.
after 4 weeks, respondents will apprise the court with regard to the release of compensation to the writ petitioner.
Respondents may continue with their work, Lordship. Respondents, the
You
NHI.
continue provided the amount is there. You have acquired the land. The man has not got it.
No, Sabonara copy এটা দিও মই পঠাই পেলাই instruction
Interim order may continue. my lord.
The matter be listed on 15th of July.
Lordship.
Interim order will continue. Further extension will be reconsidered on 15th of July.
Obliged.
দিয়া নাই নেকি?
নাই দিয়ে নিদিলে মই কেনেকে instruction পাম মই গমে নাপাওঁ কি হয়।
The lordship is the order, last order.
Yes, any instruction?
Lordship, I have communicated and received telephonic instruction that bamboo fencing is erected on government land, not on the petitioner's land and disputed land, Lordship. I have not received written instruction, Lordship. Telephonic instruction.
All right, let them get their instruction.
Section, my lord, only thing is that already they have enjoyed one portion of that.
There is a contempt matter.
No, that is there, my your
What is the
lordship.
status of, what is the status?
Specifically, order was there, my.
What is the status of the writ petition?
Hello?
What has happened to the writ petition?
No, it is pending, my. They have submitted the reply also. They are very much aware of the order
So
also.
let this matter be listed along with the writ petition.
So that can be done only in the meantime, my lord, let them say, my lord, so that the court order may not to violate.
You get your, file your affidavit immediately.
Lordship, a notice not received. This is contempt matter, Lordship. Notice had to go to.
Your lordship directed us to give a copy that was given to them.
All right. Third learned
Lord-
city council. Chairman Chaudhary, assisted by Mr. Chaudhary. And Mr. Purva. So you are not appearing.
I am not, wakalatnama have to be
Issue
given.
notice on the respondent. The contempt petition is filed stating willful disobedience of the order dated. Which order?
25, page 12. 25/7/27. 23.
5/7/2023, past date WBC number 4171 of 2023. So it's submitted that though the order of the court, though the writ petition will be pending, there is a specific direction the respondent authorities, namely respondents 2, 3, and 6, who are present here, respondents 1, 2, and 3.
Yes.
The writ petition not to interfere and disturb the possession of the petitioner in respect of land covered by DAC number 205 and 206, included in periodic pattas number 105 and 132 of Bosar, Eta number 22 near Topoka, Nogam Road, under Dunamu Punza, Topoka Revenue Circle, as well as the building standing there till the next returnable date. Stop. Counsel for the petitioner submit that the interim order still subsists, and an affidavit has also been filed by the writ petitioner,
By the respondent.
by the
Government.
respondent, stating that no eviction is
Deputy.
carried out in any PP land of the writ petitioner. Stop. However, petitioner is before this court saying that they have erected a bamboo fence,
Yeah, paragraph 10 of my madam.
bamboo fence
Page
there
7.
on their land, and there is imminent threat of encroachment of the land and causing damage to the building standing there. Therefore, contempt order has been filed as there is a steps of the respondents by registered post AD along with reports will be taken within 1 week.
2 days.
Within 1 week. Please take over.
Obliged.
Yes, affidavit, Mr. Sharma.
They have filed their affidavit.
They filed.
They have filed their affidavit. Lordship, in the page 28 of their reply, they have stated, they have admitted that no.
There is no affidavit here. WPC 1932.
190.
There is no affidavit here.
I have received a copy of.
You may have, but it is not here. Learned counsel for the petitioner submits that an affidavit has been filed with the respondents. However, a copy of the state affidavit is not connected to the writ petition. Therefore, registry is directed to list this matter again on 15th of July, by which date the affidavit stated to have been filed by the respondent will be connected to the
Okay.
Ma'am, I need some time. I have to take some instruction from my father.
really learned counsel petitioner for some time to complete with this. The matter Mr. H. Sharma, an advocate, represent the respondent number.
3 number to Niki.
6 number.
That GAUHATI amount has already been released to the petitioners, Lord.
2, 3,
This is the one has been
4.
needed.
MSG Adoriga for number 1, MS Arbora for 5. Matter be listed after 4 weeks. After 4 weeks.
Please, Lordship. Lordship, on the 3rd of June, Lordship, this matter came up for motion. I had submitted before your Lordship that my business was closed, so notices were not served upon me. Consequently, this court ordered the respondents to produce the record, Lordship. Subsequent to that, they were not able to produce. Today, I suppose they have the records.
Record says that the address which was provided by the petitioner notice was sent. Total endorsement is that the address is left.
Huh?
Address is left.
Left.
As many as 5 notices were sent.
Since my business was closed down, Lordship.
And Lordship, they are choosing the same address in the writ petition also.
So, Lordship, since the notices were not served, which was my case, I am just wanting one chance so that I can produce relevant documents.
It was served in the address.
No, it returned back, Lordship.
No, it returned back because you were not there.
Lordship, my business closed down. That is my pleaded case.
No, so what is the question of your business closed does not mean your tax liability will also be closed.
No. Tax
Then-
liability, I will contest. I will
then-
pay, Lordship.
then-
Whatever is payable, I will pay. My only contention is, Lordship, I was not afforded with a reasonable opportunity of being heard.
You have given the address which is marked here.
Lordship.
Then
Lordship, business
in the
moved
writ petition
on.
itself.
Subsequently, they never got an opportunity to change their address. So I have to give the address whatsoever was there at the time of registration.
So therefore, if you say this is the address, any document served at the correct address is deemed to be served.
Lordship,
That's the law.
If I may be allowed to submit, Lordship, there are two matters which need to be considered, Lordship.
Yes.
My first submission will be that since notice was not given to me, even if for my fault, if I was deprived for contesting my case, Lordship, since I have all the invoices which I have enclosed with this writ petition from page 18 to page 38, Lordship.
That is already rejected in view of there are so many judgments of the effect.
Non-submission of invoices because I could not get the notice, Lordship. That is the first aspect of the case, Lordship.
No, you cannot, your claim that notice was not served cannot be accepted in view of the fact that the notice was addressed to the correct address, which is also reflected in the writ petition.
If your Lordship holds so, Lordship, that is the first aspect of the case.
Right.
Now, subsequently, as your Lordship has rightly held so, I wanted to exercise my right of appeal, Lordship. So, when I tried to file an appeal, the system showed some error which is apparent at page para 17 and 18 of my writ petition, Lordship.
Yes.
If I may please read, Lordship. The petitioner begs to submit that thereafter they had appointed a consultant for doing needful to contest the impugned order by filing an appeal. But their consultant informed them that the GST portal is not accepting the appeal of the petitioner, as the appeal can only be filed after complete payment of taxes as calculated in table 15A. And the petitioner was shown a message to make the payment of balance dues and try again to file an appeal. The consultant also informed the GST portal does not allow
You're reading from which page?
Lordship, para 17, page 10.
Yes.
The consultant also informed the GST portal does not allow the petitioner to pay pre-deposit of so and so rupees as outstanding return liabilities were pending with a request to pay off the said dues first. Upon searching of data, petitioner came to know that return related liabilities of 7 lakhs were pending under CGST Act and SGST Act, and a sum of 7 lakhs was available in the cash ledger of the petitioner for payment of such dues. But as the petitioner is not in a position to pay off the old dues at once, the GST portal does not allow the petitioner to make payment of pre-deposit of so and so rupees to exercise their right of appeal in the matter. Subsequently, Lordship, paragraph 18 will also be relevant.
What is your submission now?
Lordship, since I could not even file the appeal because the portal deprives me. Lordship, what happens that the GST Act came into play in 1st of July 2017. I filed returns for 3 months, Lordship, July, August and September 2017. They said there are some dues relating to those months. Because of that dues, I cannot be deprived of my right to appeal, Lordship. They have all their provisions to recover my dues.
Right to appeal is a creature of the statute.
Lordship?
Right to appeal is the creature of the statute.
Yes, Lordship.
So whatever the statute provides, this is the parameters you have to satisfy before filing an appeal.
Pre-deposit I am willing to pay, Lordship, but they cannot deprive the right to appeal because of some other dues. That is my case, Lordship. They said that some other dues are pending, so I will not take pre-deposit for appeal also.
If it is, you challenge, see, these are the provisions of the statute. For your case, we cannot mold, we cannot interpret
it is not required, Lordship. It is not required to be molded at all, Lordship. My only pleaded case is, Lordship, I want to exercise my right of appeal. For that, I need to make some pre-deposit, and without any provision debarring me from payment.
That will amount to changing the narrative of the statute.
No, Lordship.
It is. You show us a provision that it is permissible, yet you have been deprived of.
No, Lordship, they have to show a provision that if any return-related liabilities is pending, they will not accept pre-deposit.
You show us from the provisions of the Act. What you are trying to interpret, you show us from the provisions of the Act.
Lordship, section 107 gives me the right to appeal. GST Act, Lordship.
GST. Yes.
Appeals to appellate authority. Any person aggrieved by any decision or order passed under this Act
by an adjudicating authority may appeal to such appellate authority as may be prescribed within 3 months from the date on which the said decision or order is communicated to such person.
Yes.
Lordship, a proviso, the subsection, after subsection 6, Lordship, there is a proviso. No appeal shall be filed against an order under subsection 3 of, unless, no, Lordship, this is the wrong provision. Lordship, subsection 6B, no appeal shall be filed under subsection 1 unless the appellant has paid a sum equal to 10% of the remaining amount of tax in dispute arising from the said order. So the act only says that I need to pay 10% of the tax, Lordship, which I went to the portal to pay. I have also enclosed the screenshot. What the screenshot of the appellate filing says, Lordship, it will be at page.
What about 6A? 6A?
Whatever tax I admit, I will pay in full, Lordship. That is regarding the impugned order, Lordship, not any other dispute.
You are seeking appeal against what?
I am seeking appeal against the impugned order, which levies a tax of 39 lakhs or like. And my case is, I am not even liable to pay a single penny, Lordship. I have all the invoices in support of the input tax credit claimed by me. So 6B will be applicable. I went to deposit 10%. Without there being any provision as regards any earlier return related liabilities, they are depriving me from my right of appeal, Lordship. This is my only pleaded case, Lordship.
Yes, Mr.
With regard to earlier text, with regard to earlier text, there are some notification. I'm at this moment, Lordship, the notification is not with me. But we may take up tomorrow or reopening day. Will place all this document.
In that case, perhaps notice may be issued with the direction of no coercive action.
Heard and accounted for the parties to notice return of 2 weeks. Mr. HCKL and appearing for the respondent. The way down the grievance of the writ petitioner is that under section 1076B, petitioner is entitled to file an appeal after payment of 25% of the disputed amount.
10%.
Sorry?
10%.
10%. However, it's submitted that you've been deprived from filing an appeal without clearing the earlier dues, which is not mandatory of the statute. I agree with his approach to this court. Praying for that. Mr. HCL, he submits that he has, there are certain notifications that he should with demands, which provides that earlier dues will have to be cleared before an appeal can be filed. He, however, does not have copies of the notifications available in court and let the matter be listed after
Lordship, in the intake
notice on the prayer for inquiry. After 2 weeks, it will come. Let the matter be listed on 22nd, 22nd July. Report to prayer. Yes.
Yes, my lord. Already, my lord, it's a settled matter. What happened, my lord? The petitioners are occupied the common land, my lord. I am not for the settlement, my lord. What happened, my lord? Common land has been occupied by the petitioners and other civil persons since 1976. In the 1999, my lord, one notice was issued by the authority concerned to vacate, directed to vacate the place, my lord. In this regard, my lord, we have first opposed the revenue board, and revenue board did not allow our application, my lord, and then we have
You are praying for a similar order?
Yes, my lord.
That page number.
Annex 8, lordship. And
Order dated 27/4.
Yes, my lord.
Mr. For Pujari,
They are illegal occupants, and otherwise, my lord, what I am submitting, my lord, with regard to my lord, that Kiosk mini stadium. You know, there were successive litigations filed one after another, and all have been, my lord, eventually, my lord, gone against the petitioners. Now, they may file a representation, my lord, seeking allotment of land. Under the land policy, of course, my lord, the respondents will take a call on it, my lord. But that will not give them ipso facto any right to remain in possession because there is an overwhelming public interest against the private interest.
there is an order passed by this court.
So that was, my lord, on the facts and circumstances of those. That
I am not paying for the settlement, my lord. I may be allowed to file my application before the authority. Since my
Paying
lord,
for what?
application, my lord, that is at page 47, my lord, starting from 19. Paragraph 19, my lord.
Page number?
47, my lord. 19, 20, and 21, my lord.
No, no, application for what purpose?
What purpose, my lord? This is state, my lord, that considering entire aspect of the matter, I have to file an application with all my documents, writ petition, and
Asking for what?
for consideration. Whether
Consideration of what?
for whether the government can given the settlement to me or not.
Exactly. So settlement, this is a government land. This is a government land.
Purely,
it is not only government land, it is a VGR land.
The
The
VGR, then how
VGR land,
settle
my
the
lord,
figure?
That was
Japal Singh is,
I am paying only for this.
lordship is well aware of
similar
Japal
order,
Singh.
my lord.
Supreme
You
Court
file your
has,
representation. If it is not disposed of, you come back.
My lord, already
Yes.
other person has filed the.
You
Yes,
file
my
it.
lord. Yes, my lord. This is enough, my lord.
You file it.
Yes, this may be okay.
No, but it is not your case that your representation has been filed, but it has not been considered.
My lord, okay, my lord. That observation I have given, my
No,
lord.
no observation. This petition, you are seeking a liberty to file a representation.
Yes, ma'am. This is my.
So, do you need a liberty? You can file a representation
My
today
lord.
itself if you want. If that particular representation is not
My lord,
given,
earlier, other persons have been, other persons already filed their representation before the authority concerned, my lord. That is pending for consideration. And therefore, I am coming before your lordship, similar pair, my lord. We may
I'm asking you why you are asking for that prayer when there is no bar for filing a representation.
Yes, my lord, I will file the representation, my lord. This observation may be like given.
no, my lord. This will, my lord, create unnecessary, my lord, because
Already, my lord,
And
stadium is going on.
we don't like to make loose of the way.
their rights have not been crystallized.
We'll have to then we'll issue notice and we'll hear the matter if you want. You want to file a representation, go and file a representation. Why do you want an order of the court, observation of the court? If they don't accept, then you come back. You think about it. Let it come after vacation.
Right.
Matter be listed immediately after reopening.
I'm so obliged.
By the as the counsel for the petitioner would like to complete the instructions. There are proposals for revenue department.
Revenue department.
You think about it because you don't require a leave from this
Whatever,
court.
my lord, I'm coming only that point, my lord. Other persons at that time, my lord, when they have approached your lordship, my
These
lord, at
other
that time, my
persons
lord, I
came.
have
These
not,
other persons came for settlement.
not, my lord, only representation.
No, their writ petition is for settlement.
Yes, my lord, that has
Then
not
the
been
court
considered.
said that okay, you go and file a representation.
Yes.
Now this is not a precedent in a true sense.
Yes.
Yes.
There is no finding.
No pending, my lord.
Therefore, it is not binding.
My lord, because my lord.
Now, if you are asking for settlement in the VGR land, straight away we'll reject it. But if on your own you want to file a representation, you go and file a representation. Who's stopping you? Why do you want an observation from the court? If you file a representation, it is not considered, then you come before the court.
My lord, I will take the instruction.
You take instruction.
I'm obliged, no?
Yes.
Non-payment of ex gratia loan.
Ex gratia. Yes, who's appearing for respondent? Respondent, who's appearing?
Revenue.
Revenue. Karbi Anglong. Anyone for Karbi Anglong?
DC Lord. DC.
So we are disposing it of.
No, Lordship.
DC will verify if the proposal is found, if it is found to be correct, it will be put up before the Secretary Revenue and Disaster Management.
No.
And thereafter they will pass appropriate order.
After proper verification. Lordship.
All right?
Sure.
Dispose.
Yes, yes,
May please the Lordship. Lordship, petitioner pertaining to Lordship, a passport Lordship. My Lordship, petitioner is a Lordship working as the life mitra under Lordship State Bank of India Life Insurance Corporation Lordship. Lordship, petitioner applied for having a passport Lordship. And one inquiry Lordship, the petitioner is found that is the
There is some case pending against you.
my Lord,
No police case.
my Lord, already my Lord, the petitioners have been granted a bail by the learned bail Lordship. I have annexed the order Lordship, kindly see page 21 and
Is there a direction? Why are you not giving him the passport?
Yes,
Regarding that, I have to take instruction, Your Lordship.
Take instructions. Our learned counsel for the petitioner is agreed that the respondent number 2, the respondent number 2 has not released, has not granted the passport to the petitioner without any basis. So, let's give CGC appearing to the respondent submits that she would like to obtain instruction. Therefore, matter be posted after reopening. Learned CGC will obtain instructions in the matter. Please, extra copies be furnished to the respondent. List again up for 22nd July.
Lordship, can it be on the 18 Lordship or 19? Because my Lord, the authority Lordship will be
19.
obliged Lordship.
Oblige, Your Lordship.
Also kindly possible with the timing.
Lord,
Is it
Korangam Goswami, he is in bereavement. We appreciate it, Lord. I think they'll be praying for time. My only thing is, my Lord, let this come up for motion on the reopening. Till then, no coercive measure.
no,
Let
but
it come.
the issue had already been decided by earlier,
Partly.
already been decided.
Yes, by Justice Borua's judgment.
Lordship, otherwise, because I have been instructed that Mr. Goswami is going to appear in the matter. The impugn order is of 30th of March. We have not done anything since.
No. But now they have issued.
Interim orders can be considered in.
No. They have issued the demand notice.
Lordship may otherwise record my submission that till the next day, your Lordship will not do anything. Interim prayers may be considered in Mr. Goswami's presence, Lord.
No, that I am not objecting, my Lord. Let it come up on after vacation. Only thing is, they will not take any coercive measure till that day.
Lordship may record my submission, your Lord. Till that date, your Lordship.
My Lord, otherwise the legal position is very clear. My Lord, we are dealing in duty paid liquor. Once, my Lord, it moves out of the manufacturing bonded warehouse.
These are with regard to what? The ones available with the retailer.
Yes. And they're saying MRP is X, sell in Y. And that is again violative of the statutory prescription.
With effect from the date of the notification.
Yes.
Or retrospective effect.
They have given retrospective effect. Now, my Lord, the consignment or the stock which is in our, possession, these are all duty paid. You can't levy. There is no scheme in the Excise Act.
There's a important point raised.
Yes.
More particularly in view of the vacation.
Yes.
It will cause unnecessary hardship to
And in fact, my lord, in one of the litigation, Mr. Goswami had made a submission. He says, Mr. Goswami Lane's Standing Counsel Excise Department categorically submitted that impugned decision will not be will be implemented only in respect of the stocks lying in the warehouse and not the stock which have already reached the retail outlet. Me too.
All right, heard, Mr. Kane of Senior Counsel assisted by Mr. And Mr. K. P. Pathak appearing for the respondent.
Respondent numbers 125, 125 here.
125. Mr. B. Gogoi for respondent 6. This petition is filed by the petitioner association.
Yes.
Claimed to be retailer of Indian made foreign liquor and are aggrieved by the demand notices issued to their members by the superintendent of excise of Kamrup district.
No, my lord, across the state.
Across the state. Directing the retailers to make payment of ad valorem and VAT on transitional stock.
On the stock lying in there, lying in the premises, your lord.
In our possession, yes.
Lying with the retailers.
Yes.
This that is notices, these demand notices have been issued pursuant to the where is the notification?
Yes. Notification is at my lord page 71. Now this is the direction. Room 4.
In pursuant to
retailers
the order dated, what is the date of the notification?
My lord,
33/2024.
33/2024. Whereby additional excise duty and tax arising out of the difference between new and old MRP be deposited by the wholesale licensee for the stock in possession. This is for wholesale license.
No, my lord, 4 is regarding retailer. 4.
Whereby the retailers were directed to pay additional excise duty and VAT for the stock under their possession to Treasury Challan / online portal for which demand notice will be issued. Senior counsel submits that this order itself reflects that this order will be made effective from 1/4/2020, and there is no scope to implement the same with retrospective effect. He therefore submits that this impugned demand notice contrary to the provisions of the Act and Statutes and calls for due interference by this. He also makes a prayer for adequate. Mr. K.P. Pathak is the notice on behalf of Mr. Boy. He is extra copies we furnished and matter be listed again, tell us.
Immediately on reopening, your lord.
17th, my lord.
17th. Yes. 17th of July. Issue notice on the interim prayer till the next date fixed. There shall be no course of action.
Lord, yes. May otherwise record my statement because
the same thing.
Lordship, because if an interim, that will be in the nature of an interim.
No, till that.
Otherwise, we are giving it till 17 only.
Yes.
Very Lord, very well.
No coercive action by the respondent in terms of the demand notice issued in pursuance to the impugned
33/24.
3003/2024. Demand notices issued to the members.
Yes.
Of the association.
Okay.
List again on 8/17.
Lordship is notice of
interim
the
order till 17th.
My lord, the interim direction will be in respect of annexal G also till that day. Page 75.
Lordship may kindly otherwise say if an observation is passed that
page 75
no
also.
coercive steps, no coercive measures will be taken, perhaps that will cover everything, your lord. Because interim periods, anyways, your lordship will be considering on the next day.
Oh, yes, that will also do, my lord. Lordship may say no coercive measure in respect of the impute orders. That will do, my lord.
Otherwise, some of the retailers have already paid, your lordship. They do not have
what
any.
happens to the sales made in the
Yes,
building?
what has actually happened, your lordship, is they have sold it at a higher MRP, your lordship. Now, when we are saying that we have sold it at the higher MRP, kindly pay us that balance at excise
Now,
duty.
Mr. Chaudhary, what happens to the sales made?
Yes,
with effect?
that has
No,
already.
my lord. Question is, we cannot sell in higher MRP. Regarding fixation of MRP, either a wholesaler or a retailer has got no business, my lord. It is between the excise department and the, my lord, the manufacturer. The moment the stock leaves the, my lord, premises of the manufactory, there is no excise department has no business to do all these things. My lord, in the name of end of the day, we are lordship
So,
will
so essentially, you are saying that this page 75
is also a demand in respect of the higher MRP. Now they which would like to fix.
So the higher amount MRP will only be applicable to those stock which is not reached your premises.
No, it has already reached. It is in our premises. When we sell, now what had happened, my lord? The MRP is fixed at the stage when the consignment leaves the manufactory. Supposing a particular bottle costs 400 rupees. Now they have fixed it, say 500. Now we'll have to sell that bottle of where 400 is written at 500 rupees. That itself is an offense under the relevant statute.
So, but if you have sold it,
Yes, they have
then
sold
you are
it at the
required to pay the duty.
higher
No,
MRP.
my lord. Please come to page 75.
Yes.
Kindly see. First one, say existing MRP 400, new MRP is 480. But this new MRP is not, embossed in the bottle. It is something which they have come out with. This is the list.
No,
Now,
that we understand.
yes.
What we want to say
Yes.
is that if you have sold it at 480,
No, we are not selling at 40. We are selling at 400. My consumer will pay a price which is not written in the bottle, Miller. Yes.
I will get the records, your lordship.
Yes. No coercive measure in respect of the impute actions.
impute demand.
Demands. Deep level.
Mr. Chaudhary, we thought this matter was specifically by you because of something which happened yesterday. The consequence of something yesterday. No. Right. And good wishes to the party.
Yes, deep level.
I'm challenging the order at page 48, my lord. What happened, my lord, is petitioner husband was registered as SSC under GST, my lord. He passed away in 2022, my lord. However, the petitioner could not intimate the department. In the meantime, order has been passed, my lord. Order has been passed as a dead person, my lord. Death certificate also will find it page 22, my lord.
Order has been passed under this notification.
Yes, my lord, but however, order is also time barred because my lord, the last date of issuance of order was 30th of April, my lord, and order is having passed on 4th of May, my lord.
Yes.
22nd, my lord, similar matter.
No, it's no similar, my lord. Because, my lord, first of all, is against the dead person. Second of all, my lord, I'm not challenging the notification, my lord. I'm saying that, my lord, the order has been passed beyond the time limit extended, my lord. Notification is page 47, my lord.
What is the time limit?
Page 47, my lord. 30th of April was there, my lord. Extended time limit, my lord. Order financial year 18-19, my lord. CL number 1, my lord, last.
My lord, it has been informed by the my lord, council appearing for CGST that my lord, time was further extended by way of a subsequent my lord.
There is no notification beyond this, my lord. I have gone for the
And when was the order passed?
My lord, page 48, on 4th of May, my lord. Report, my lord, right side.
Where is that notification, Mr. Yeah. There is a notification
Doctor, there are extension notifications.
subsequent to this
Yes, sir.
It was the last.
28th of December.
Yes, sir. In the month of May, some notification. It is issued by the central GST.
Then let us.
My lord, now I have gone through all notifications, my lord.
He is the study
lord.
counsel.
My second, my
If he
second,
says it is there, then
my lord, my lord.
we
No,
should give him
my second, my lord, my second argument is that my lord is against dead person, my lord. Lordship will see, my lord. The order is passed in the name of Satyajit Bordle, my lord. He passed away, my lord, on 2nd of November 2022, my lord.
No, it all depends on the in whose name the registration is there.
It was in the name of Satyajit Bordle, my lord. I have another certificate. Certificate of Lordship will find it page 18.
So, in respect of the dues payable under to the state and center,
My lord.
the legal heirs will be responsible.
The proceeding was against the dead person, my lord. That's what I'm saying.
The proceeding was how will the department know that he is dead unless you inform me?
My lord.
There was no intimation that he had expired.
Lordship may fix tomorrow. Let them put in the notification of extension if it's really there, my lord.
Can you produce it tomorrow? Tomorrow?
Yes. My lord.
Let us have it tomorrow.
My lord.
This matter tomorrow. As Standing Council, GST, that there is a notification, further notification, extending the time pursuant to the notification dated 23rd,
28th of December.
28th
My lord.
of
December
December 2020. Release the matter tomorrow. 28th.
No, this one regarding force measure, my lord. So Lordship has fixed the matter on 22nd of July, my lord. Apart from that, my lord, I have some other grounds also, my lord. This order has been passed in violation.
And counsel for the parties issued notice.
Second,
My lord.
Similar matters are fixed on 27. Therefore, the question raised in the petition is whether COVID-19 is the ground. COVID-19 can be interpreted to understand the meaning of force majeure as prescribed under Section 16 A of the CPS Act. Mr. SCKL and studying out as well as Mr. D. Boyd, studying out for state PSP and PSP submits that there are judgments of the High Court of Kerala,
Kerala and Allahabad.
Allahabad High Court, which have decided this issue and dismissed the contention raised by similar matters have been heard. With this matter also treated to be partnered and question of law is to be decided in this matter. All these matters listed together on 22nd of July.
Yes, sir.
But till then, no coercive action, my lord.
Till then, no coercive action.
Deeply obliged, my lord.
Against the writ.
sorry, my lord, I must have got it.
Yeah.
My lord, this it's very innocuous. I don't know how an order has been passed by the circle officer. Circle officer doesn't have a jurisdiction also. There is a gift deed which was in my name, which was given by way of a gift deed by my grandmother. Now my brother is against this gift deed and he's saying that this is a forced gift deed. Now he lost an FIR. I took a bail, anticipatory bail. Thereafter, he makes a complaint on the basis of before the revenue department. And my lord, when we appeared, notice was issued to us. 2 applications were filed. We said, please give us the copy of the complaint respective document, not being provided. Second time we went, then it was provided. Then we filed a preliminary objection. We said to the circle officer, you don't have a jurisdiction also. If you are challenging a force deed under 41 of the Assam Land and Revenue Regulation, my lord, it is only before a competent court. Kindly see this, my lord. And the matter is under investigation by the police. kindly see, my lord, the the notice which you have served to us. At page 40, my lord, will kindly see. First notice, if your lordship will kindly see at page 36. First, your lordship will kindly see the gift date at page 23. This is a gift date.
20?
23 is a gift date. Gift date 24th of December 2007. On the basis of the gift date, which is 2 kata 10 lectures, we are in possession of that land. Debojani Chaudhary, and this is my grandmother, which is given to Tridip Chaudhary, which is a petitioner, the grandson. Now this is being gifted. On the basis of this gift date, my lord, there was an FIR which is being lodged by my brother at page 31. What he says, my lord, on the second paragraph, he makes a description on the first paragraph, the plot of land measuring so and so. Second paragraph, on an RTR reply received by me on 6/5, by letter number so and so from APDSL regarding the change of consumer electricity number in the name of Tridip Chaudhary, it has come to light that Tridip Chaudhary, by submitting a forged gift date bearing number so and so, purported to be executed before the office of the senior sub-registrar Kamrup, along with a false affidavit stating the time of death of our grandmother late so and so had left behind Tridip Chaudhary as only the legal heir, which is completely a false declaration made by him. So this is so on, he goes on.
Any suit filed for cancellation?
No, that's the whole case. They have not filed. And if your lordship looks into 41, kindly see 41 miles of the Assam Land and Revenue Regulation. 41. Take on, Lord. Hey, not new amendment. No. Yes, right.
Yes.
So 41 kindly be seen now. 41, section 41 of the Assam Land. Entries in records and their effect. Entries in the records made under section 40. So mutation is in my name. I am in possession. Shall be founded on the basis of the actual possession. All the dispute regarding such entries, whether taken up by a settlement officer of his own motion or an application of party concerned, shall be investigated and decided by him on that basis. And all the person, and now kindly see, read this minor, and all person not in possession, but claiming the right to be so, shall be referred by him to the proper court. That is the civil court. Now there has to be cancellation of the gift deed. On the basis of mutation, we will be cancelled. Thereafter, the investigation. No, matter is already investigated, my lord. If he is really aggrieved, let him file a civil suit, my lord. He cannot. And what has happened on the basis of preliminary objection which you have filed, he sends 4 of the police officers, 2 of the lot mandals, and they said we will now demarcate. Where is your power? That is why we have come up before this court. We have made a specific averment before the court. Kindly see, my lord. Page 12, kindly be seen, my lord.
Yes.
Para 17. Para 17. That after the filing of the, at page 12, para 17. That after filing of the aforesaid preliminary objection by the petitioner, raising maintainability of the proceeding, respondent without deciding said preliminary issue on 21/6/2024 at about 1 p.m. sent some official from his office along with some police officer from Gitanagar police station without issuing any prior notice to the petitioner to demarcate the land in question illegally and in collusion with the respondent number 4 and tried to demarcate the land. After seeing the same, when the petitioner asked the official to show him any office order notice to the effect, They failed to show any such order notice and told the petitioner they have come as per instruction of response number 3, as there is no such written order. After hearing the same, petitioner did not allow the official from the dispute revenue circle demarcate the land. However, the said official told the petitioner they will again come and they will hand over the possession of the land to the response number 4. It is further mentioned herein that in a complaint dated 5/3/2024, response number 4 has not paid for demarcation of the land in question, but response number 3, without any application of mine, without any sanction authority under any law, by misusing his official capacity and his official to the land in question, that too without serving any prior notice to the petitioner. Therefore, such conduct of response number 3 clearly shows his ill intention. Under law, my lord, 41, you are saying that this gift deed is forced. You go before civil court, cancel it. And where is the power? The police is investigating. They are troubling unnecessary.
Supreme instructions, my lord, notices may go.
Heard Mr. Digas assisted by SDECA. Appearing for the writ petitioners and SHRI.
2 and 3, my lord. 1, my learned friend.
The authority of petitioner is agreed by the. Is there any order passed by the?
No.
By is agreed by apprehended is agreed by actions taken by circle officer, revenue circle, to demarcate a portion of land, demarcate the land, which is in his possession.
I'm in possession, yes, long back.
Which is in his possession. Stop the measure of land is waters dead letters covered by document 89/19 323 of Patna number 34 village Rapurigo to the Belpona. Stop. It's submitted that this land was donated, it was gifted by execution of a gift deed on 24th of December 2007 by the donor,
grandmother,
Srimati late Devajani Chaudhary, grandmother, the petitioner, as well as the donor. Stop. In pursuance to an FIR lodged by the responsible with the police station, making allegation that the gift deed is a forged deed. The respondent, the circle officer, circle officer has made attempts to demarcate the land for the purposes of mutation. So, council referring to section 41. Regulation 41.
Yes.
The Assam Land Regulation submits that under the regulation, if any person who claims to be the owner of the land but not in possession is ready to be referred to the competent civil. As such, circle officer has no jurisdiction to entertain this matter. Stop. To the best of his knowledge, there is no civil suit pending questioning the gift deed, authenticity of the gift deed. Only an FIR has been filed and investigation in that respect has carried on by the IO and the petitioner is pending arrest and also obtain an anticipated date. And such circumstances that the respondent number 3 should be directed, should be suitably directed not to take any steps to demarcate land without there being a proper till the matter is decided by competent. Contrary to the, not to demarcate the land contrary to the claims of the petition. Like that. Is there now what is
My
the
lord,
apprehension?
kindly see 21. we said that 21 prayer. We have asked for stay of their impugned proceeding on this case.
What proceeding?
That he is initiating, circle officer,
Where is that proceeding? Detail?
56 of 2024.
Page?
Notice has been sent.
Page?
Page, it starts from page 36.
36. So why should we stay this proceeding?
Otherwise he will go, he doesn't have a jurisdiction. 56. The proceeding, where is the jurisdiction? If it is a gift deed has been forced, then it is only, he doesn't have a jurisdiction.
We give you the protection, but you have to agitate this matter before the competent authority. Why
We have
proceeding
agitated.
should be stayed?
Preliminary objection has been filed.
That's right.
Page 48.
Let the proceeding carry on.
But they will not take any coercive measure. No coercive measure, my lord.
Let the respondents obtain their instructions in the matter. And they see prima facie until and unless the ATC passes an order, the circle officer passes an order. Can we restrain him from
no, he is not taking, he is not passing any order intentionally. He is sending his person to my residence. That's not the way you will do it, my lord. That's the whole problem, my lord. No coercive measure should be taken.
No, what coercive measure?
He is
Coercive
taking,
measures for what?
he is taking, he is sending to take, his only intention will take the possession, demarcate it and take the possession, throw me out. This is the whole difficulty, my lord.
No, but there is a process for doing it.
I'm sorry?
There is a process for doing it.
He does not,
why are you apprehending?
he does not have the jurisdiction also to initiate this proceeding, my lord. That's the
right.
whole case.
We will decide on this matter.
No,
but
it's
at
true,
this
my lord.
stage, to stay the entire proceeding.
Then he will go ahead, my lord. Then he will go ahead.
If he goes ahead, you have to challenge this order.
He'll take the
provisions for an
consequences,
appeal.
my lord. If he
my
does
lord,
anything
if
illegally,
he
he'll
doesn't
take the
have a
consequences.
jurisdiction, can he file this, can he send a notice to me?
That's right. But there is a proceeding initiated. He being an authority, he has to pass an order.
He doesn't pass, that's the whole problem, my
That's
lord.
right.
He's in collision with the private respondent.
Have you named him in person?
No, I have not person, my lord. He's a circle officer, my lord.
So,
Not in circle officer.
you are making allegations that he's in
But,
collision with
but,
respondent.
my lord, but he should not take any coercive measure by taking
What coercive measures are you apprehending?
position in respect
How
of
can
the.
there be a possession by the circle officer?
He's doing, my lord. That's the whole problem, my lord. That's the whole problem, my lord. He's doing it, my
His
lord.
allegation, my lord.
So he is only sending some persons to, I don't know, maybe to take measurement or whatever.
Can he take, my lord? Can he take this measurement under the law? Where is the question? Is there is no prayer for demarcating this land?
Where is that application?
Yes. 43 is there. Same FIR, he say, kindly see 43. 5/3/2024, reporting courts give deed. I am writing to bring your attention concern finding related property as house number so and so. As a legal error of so and so, I identified several alarming issues. A photocopied purportedly registered give deed.
There is some other mutation case pending here.
Where?
Page number 44.
Yes.
There is some mutation case pending again.
No, that has been filed by him, my lord. That mutation. Mutation, failure to produce. I have lost his concern, APDCL, same contention which I have raised in the FIR. Kindly see the FIR, my lord. Kindly see the FIR.
No, see, if you see the notice at page 36,
Yes.
this is the miss case number 50
Yes.
on the strength of some complaint.
Yes.
But in this particular page number 44,
Yes.
there is the reference to some other mutation.
But Mati, my lord, kindly see the bottom. 46, my lord, kindly see bottom. It's a miss case 56 of 24 in 46, my lord. 46, if you see on the last down bottom.
No. What we want to know is the circle officer, whether he has the power or not under the provision, he has to pass an order.
Yes.
He has to pass an order.
He is
If
not.
we stay the proceeding, how will he
No, let him pass an order, then my lord, no coercive measure should be taken. In respect to the position of the petitioner. I am in possessing, my lord. I am in possessing that property.
So therefore, we are asking you in which matter you are apprehending eviction from that particular land.
56 of 2024, where a miscase has been, my lord, issued, a miscase has been registered, notice has been sent on the basis of the gift deed which has been executed, which I am in possession.
Is page number 36, the case referred here, is this the case that you are apprehending?
That's an earlier mutation, my lord. Earlier mutation case.
In my
Earlier mutation which was in my favor. Which was in my favor, my lord. Case regarding cancellation of record, correction in connection miscase. So, my lord, on the basis of gift deed.
So see, you are asking for an interim order. Whether the authority.
I'll tell your lordship. Please hear me. A gift deed was executed. I am in possession of that property. On the basis of the possession, a mutation has been applied. On the basis of the records of right was in my name. Corrected. Now, what has happened, my lord? He files an application before the authority for cancellation of records of right, which was in my name, which you are looking at page 36.
alleging
This alleging that that particular force deed is a gift deed. On the basis of that, he files a mutation. Now, one, he cannot cancel the mutation without the gift deed, which is still
passed an order for cancellation.
Yes.
That I know, my lord. He has not passed. But the only is circumventing all this. He is trying to hand over the possession.
So
Throw them out.
should array him as a party. That if he's playing forgery, if he's in connivance with the private respondent, then you have to array him as a party. Otherwise, see, he has a case before him. According to you, he cannot pass an order. But he has not passed an order.
He has no jurisdiction to pass an order. This notice itself is
it is for the authority to decide whether they have a jurisdiction or not.
In the meantime,
can a different authority decide whether?
No, let him decide. But in the meantime, he will give the possession to him. Lord Mandal is coming. They will demarcate.
Your possession. That is what you said.
I'm in my possession. I'm in my position. My position should not be disturbed. My position should not be disturbed. That's what I am saying, my lord.
That will be a matter to be examined by a civil court, my lord.
Let notice be issued on the interim prayer. Returnable on the same date. Till the next returnable date, tell us when you can get your instructions. 29th July? 29th July?
My lord.
Returnable on 29th July. Till the next returnable date, the possession stated to be the possession of the petitioner as claimed shall not be disturbed without leave of the court. Possession of the writ petitioner on so and so land.
Yes, on the land.
On the land, demarcated in annexure
mentioned in the gift deed.
The gift deed stated to be in possession of the writ petitioner shall not be disturbed without leave of the court.
In the prayer also we have mentioned. Deeply observed.
Please, your lordship. Lordship, item number 16, lordship, can it be taken as last motion matter?
Why?
Lordship, I am awaiting one instruction. Lordship, last motion matter. 16, lordship only.
But on 22/7, my lord, similar issues are coming up. Our lordship has already fixed item 15. Same issue, my lord, same notification.
But I would like to only last motion.
Yes.
17. Maybe 17. 17.
Same, no.
Lordship, in item number 17, lordship, there are two issues which we are challenging in this lordship. We have come directly against the impugned time barred order dated 28/2024. Lordship, the other issues regarding the lordship force majeure clause as well as recommendation of council and lordship, these are there. Apart from that, lordship, the major issue which is there in this writ petition is that lordship, I am challenging that lordship 16(4). Lordship, I am not challenging the provisions of section 16(4). Lordship, when I lordship purchase a good from a supplier, and I sell the goods, I am entitled to an ITC on the tax which I have paid to the supplier. Now, Lordship, that ITC which I am getting, Lordship, section 16 puts a bar to it. That you have to, all the filters which has been put under section 16, you have to cross that, Lordship, section 16. Section 16. So, Lordship, section 16(4) puts an embargo. Lordship, I have paid my tax to the supplier. Supplier has paid to the government. This is the case, Lordship, my case. But, Lordship, section 16(4) says no. You can't take the ITC unless and until you have filed your returns on time, within the prescribed period under section 639. Lordship, 16(4), a registered person shall not be entitled to take the ITC in respect of any invoice or debit note for supply of goods or both after due date of furnishing of return under section 39 for the month of September following the end of the year to which such invoice or so and so pertains. Lordship, this
Proviso.
Lordship,
Proviso.
provided that the registered person shall be entitled to take input tax credit after the date of furnishing return under section 39 for the month of March 2019 in respect of any invoice. Lordship, it's only for the month of March. In respect of an invoice relating such year, debit note for supply of goods or services or both made during the financial year 2017-18 and so and so. Lordship, my case is relating to 2018-19. This proviso will not apply to me. Lordship, now what has happened, Lordship? This Lordship provision, Lordship will see that since Lordship is seeing the amended provisions, it is written, Lordship, in the section 16 for 30th day of November. 30th day of November is written. Lordship may kindly see the second line, both after the 30th day of November. Lordship, this is the amended provision. When 2018-19 was there, this amendment was not there. Lordship may kindly see the subnote.
Yes.
It was, Lordship, earlier it was September. This has been amended, Lordship, with effect from Lordship 1/10/2022 by way of Lordship notification. Lordship, may I this notification section 100, next page, Lordship. This was the Finance Act 2022, Lordship, section 100, subclause B. B says, in subsection 4, for the words figures, due date of furnishing of return under section 39 for the month of September, the words 30th day of November shall be substituted. So, Lordship, for the future period, it is November, last date of filing the return. So,
It is substituted by 30th day of November.
Yes, Your Lordship. Now, Lordship, so far as my case is concerned, Lordship, my case is relating to the assessment year 2018-19. For me, Lordship, the period of September only will be, Lordship, included. So, Lordship, I had filed the date, the return after September, but Lordship, before November, 30th day of November. So, Lordship, I was, Lordship, praying that just 14 days of delay is there, Lordship, in my case, 14 days of delay is there. Lordship, in a similar case, Lordship, the Kerala High Court has held that this is condonable because, Lordship, that time the glitches were there. When you were allowing the Lordship from 2022, you are allowing the persons to file the return in the month of November and allowing them to take credit after November. Lordship, that time it were glitches. People were filing returns delayedly. So, Lordship, the Kerala High Court has held. Lordship, this has been accepted by the GST Council also. Lordship, may kindly, Lordship, this judgment, Lordship, page 35, if your Lordship may kindly see. Page 35. This has been accepted by the GST Council, Lordship. They have given some effect, but Lordship, my order has already been passed. 35.
Good.
Paragraph 33, Lordship. Delay in making the entries within the time fixed should not be the basis for denying the benefits of ITC. This is my submission, Lordship. It is further submitted that ITC is a facility of credit, and it is in the nature of vested rights. The credit earned under GST is the property of taxable person. Therefore, denial of ITC would be violative of so and so. This substantial benefit cannot be due to procedural lapse of mere non-disclosure of GST or PB within the due date, since the details of ITC are already available in so and so, which is available with the department prior to due date of prescribed under section 16(4). This was the submission, Lordship. Lordship, thereafter, Lordship, may kindly see page 87, where the Lordship, the judgment is there. Herein, Lordship, the 16(4, Lordship, they had challenged the 16(4) provision also. That was not taken into account, but Lordship, the delay was condoned. Only a High Court under the Lordship provision of Article 226 has the power to condone this delay. Page 87.
Okay.
Lordship, fifth line from the top. The amendment is only procedural to ease the difficulties initially faced by the dealers, taxpayers. Therefore, when the period from 1/7/2017 till 30/11/2022, if a dealer has filed the return after 30th September and the claim for ITC was made before 30th November, claim for ITC of such dealer should also be processed if he is otherwise entitled to claim ITC. It has also been pointed out that in several cases which are pending before this court, the claim has been made before 30th November of the succeeding financial year, but the relevant period was 20th October, which was extended date for furnishing the return under section 39 for the month of September. Therefore, if a person has furnished the return for the month of September till 30th November, their claim should also be considered and processed and should not be rejected if the dealer did not furnish the return for the month of September on or before 30th October. Because this amendment being procedural has to be given retrospective effect. Lordship, Lordship,
you filed your returns when?
My returns were filed, Lordship, in the month of November, Lordship. I filed it on 4th of November. So there was a delay of 14 days. Lordship, this has been accepted.
How is it 14 days? In your case, it was in September.
September, Lordship, it was extended to 20th October. Lordship, may kindly see the GST Council, Lordship. Yesterday I was asking, Lordship, the GST Council recommendations are also there. This is the paper, Lordship, press release. Lordship, may kindly see the second point itself. Lordship, this is accepting the judgment of this Madras High Court, Kerala High Court. GST Council recommends the time limit to avail input tax credit with respect to any invoice or debit note under 16(4) of CGST through any GSTRB return filed up to 30/11/2021 for assessment year 17/18, 18/19, 19/20 and 2021 may be deemed to be 30/11/2021. They have accepted that November should be the date. Lordship, but this is just a press release, Lordship. This will come into effect. The no notifications have been issued as that. It will take a lot of time. So my humble submission is, Lordship, I'm at this stage, Lordship, praying for a Lordship interim inspection, and Lordship notice may be issued. So far as Lordship, this time bar order dated 28/2024 is concerned for assessment year 2018-19.
In your case, the ITC was rejected, denied.
Denied only in the ground. Otherwise, Lordship, I had paid the tax.
But,
the same has been paid to the government.
There are two different issues here. Why
Yes.
you?
Well, Lordship, notification has already been issued. And
One is this extension of the delay. One is this limitation.
Limitation, Lordship, in this case is there, but Lordship, Lordship, I am only harping on 16 because Lordship, that is a more pressing issue. Lordship, that limitation.
No, I'm asking you if you're pressing that point or is it only 16(4).
At this moment, for the purpose of Lordship taking an interim order, Lordship, I am only at this moment, Lordship, pressing on this 16(4), and I'm asking for a condonation of delay from this honorable.
No, but then we'll have to record it that you are not pressing 168A.
Lordship, I am 168A is also one of my Lordship prayer in the petition, and Lordship 168A, Lordship, I have got other arguments, not only fourth major. There are other issues which I want to challenge in the so far as limitation period is also concerned. Lordship 56/2023, which the notification due to which the limitation period has been extended for the year 2018-19, But Lordship, my this suffice if I am Lordship. That may also be noted, Lordship.
Yes, Mr. Gogoi.
Here also page 131 of this petition. Relevant portion, the what my learned friend has mentioned is it is in the 8.3, 8.3, 8.4, and 8.5. 16.4 is, may I read your Lordship, 8.3. The constitutional validity of 16.4 of the CGST Act 2017 was put into question before the courts of India. Recently, the Andhra Pradesh High Court in the case of so-and-so 2023 7 PM states that, I read the paragraph 25, your Lordship, relevant point. Though the above discussions deal with the ITC claim related to the concerned state laws, however, concept of ITC is one of the same, and those decisions will equally apply to the case on hand. Thus, it clear that the ITC being a concession benefit rebate, the legislature is within their competency to impose certain conditions, including time prescription for validity, availing of such rights, and the same cannot be challenged on the ground of violation of the constitutional provision.
Not telling the validity of 16.
And accordingly, on the basis of this judgment, observation have been made. And that is a punitive part is under part on order. That is the amount there.
It's not challenging it. We are, this is not a
Agree by order. Where is your impugned order?
my impugned order. Page 121.
Dated 28/3/2024 by the State Commissioner, State Administrative Richard. Confirming a tax amount of 9,494.57 for excess/wrong payment of input tax credit for the financial year 2019 in terms of section 7(3) of the CST Act. The amount was already deposited by the commissioner, and the same was returned to the free. Demand of tax amounting to 10,606 has also been confirmed, along with the demand of tax 35,894 on inadmissible licensing. Further order passed imposing late fee for delayed filing ESTR amounting to 300 and penalty of 4,47,500. Was imposed. Council that accede to the same order of ground first that the proceeding are timered and therefore proceeding the extension of limitation in terms of limitation by its plan of Kerala High Court under the MS Trade Links submits that the Kerala High Court has similar matter at appeal claims of input tax credit, benefit in respect of the petitioner there. So, submitted that this benefit amounts to a vested right of the petition. Therefore, the same cannot be taken away. Even if there is something in compliance with the certain council and further a rapid press note released to rapid the 53rd recommendations of the 53rd PST submit that the time limit to avail the input tax credit with regard to any invoice or debit note under section 64 of the CGST Act through any PST return filed up 30/11/2021 for the financial years 2017-18, 19-19, 19-20 and 2021 is deemed to be 0/11/2021. So, Senate Council that is these recommendations of the GST supports the contention raised by the defense that notwithstanding supports the contention of the defense that the time limits to avail the input tax credit in respect of the financial year in concern, it is 2018-19, should be deemed to be 30/11/2021. So, in that respect, the denial of the payment of input tax credit by the valid law and corporate that the purpose and every dependence Mr. Dr. Boy studying on the other end refers to
8.1, 131 page. 8.345.
Submits that the Andhra Pradesh High Court in so-and-so case like 121 in similar matter had held that the withdrawal or denial of ITC benefits cannot be challenged on the ground of violation. Therefore, there is no infirmity in the order. There is no infirmity passed by extent of petitioner had paid for 5 lakh. Therefore, by the order, the ITC was correctly denied. So, he, however, submits that he is yet to receive complete details of the recommendations of the 53rd PST. Considering the issue of 4 weeks, the respondent represented by Mr. Having been represented, this is the way now respondent replied their affidavit. Let this matter also listed along with other similar matters fixed on 22nd of July. In the meantime, the next date fixed, no corrective action shall be taken against the resolution in terms of the reviewed order dated so it's a past date.
Lordship, item number 20 and 47, both are similar.
See that. 20 and
20.
Yes. Where is that impugned order?
Lordship, the impugned order is page 187.
Impugned order at page 195.
Lordship,
Is the effective operative part of the order?
yes, your Lordship.
195. Impugned order dated 12/3/2024.
As well as Lordship, their demand notice or DRC 7, 1/5/2024. They have issued a
As well as
DRC 7 dated 1/5/2024. Earlier it was notice of demand, Lordship. Notice of
Right.
demand.
We are giving you no interim protection.
Your Lordship, here in this case, 9.0, my state.
47.
Impugned order
Lordship, page 113, 29/4/2024. 113.
impugned order dated 24. By the Government of State Bank. Second copy. Double 341. Your AOR has kept these papers upside down, so it's becoming a little difficult to. Huh?
Okay. Lordship, and Lordship, what happens? The state is given different type of order. The central is given different type of order.
Sorry?
Order is at
Where
page
is that order? Impugned order?
Lordship, 113, 113.
But there is no denial of ITC here.
Lordship, the
The
ITC,
recital of the order.
the Lordship, in the order, Lordship, they are confirming the SOCO's notice. Normally, Lordship, this is what the
right.
state government are doing. They are merely confirming the SOCO's notice. SOCO's
Where
notice
is
is
the
at page
SOCO's?
106.
106.
Yes, your Lordship. SOCO's notice is na 106. नहीं, 106. Lordship, page 99. 106 में मैं reply.
Right. Ordered. Dated the court, confirming the access claim of ITC.
No cultivator.
It is rectified.
Yes, Your Lordship. It was open check.
The next to check. Get it in mind.
It is 19 and the correct.
Yes.
Made titular. My lord, here, my lord, a stopwatch was issued, my lord, against which order was passed. I preferred an appeal, my lord. Appeal was dismissed as time barred, my lord. My lord, while passing the order, my lord, the appellate authority has not considered the extension of limitation granted by Supreme Court, my lord.
Yes, Mr. Yep.
Lordship, first my submission, Lordship, there is an alternative remedy under section 86 of the Finance Act. Appeal lies to the, and Lordship may please to see page 141. Paragraph 12.
141. Yeah.
Serial number 3 of the section 85 of the Finance Act provides that an appeal shall resume within
You are reading from page?
Page 141.
141. Para number?
Para number 12.
There is no 12 here, 11 and then
Lordship, stamp is there, probably it is in. And serial number 3A of section 55. The Finance Act 1994 provides that an appeal shall be presented within 2 months from the date of receipt of the decision of the order such adjudicating authority made and after the Finance Bill 2012 received the assent of the President relating to service tax, interest and penalty. Then paragraph 13. Going by the above mentioned serial number 3A of section 85, the period of 2 months in the instant case would have expired on 12/4/2022, whereas the appeal has been filed on 27/5/2022. Even 1 month extension of the Commissioner appeals can allow for expiry of 12/5/2022. Further, I examine the delay in terms of judgment of the Honorable Supreme Court in Somoto number so wherein in para 3 has been ordered in case where the limitation would have been expired during the period from 15/3/2020 till 28/2020, notwithstanding the actual balance period of limitation maintained, all persons shall have limitation period of 90 days from 1/3/2022. In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that the longer period shall apply. Since the expiry of limitation period in the instant case is falls beyond 15/3/2020 and to 28/2/2020, the benefit of the aforesaid judgment is not applicable in the instant case, and as such the appeal was dismissed on ground of limitation. Lordship, then come to page 133, Lordship. Paragraph 2A.
Two?
2A, last, page 133. In case, in any other case, the appeal shall lie under section 87 of the Finance Act 1994 to the Custom, Excise and Service Tax Tribunal at Calcutta within 3 months from the date on which the order sought to be appealed against is communicated.
Further appeal not filed.
No, my lord, coming, my lord. What happened is that, my lord, the appellate authority has wrongly interpreted Supreme Court's order, my lord. Supreme Court orders say, my lord, Lordship will say sumo order at page 127, my lord.
Yes.
My lord, relevant paragraph, Lordship will find at page 129.
Yes, yes.
May I read, my lord?
Yes.
The order dated 23/3/2020 is restored, and in continuation of the subsequent orders dated 8/3/2021, 27/4/2021, and 23/9/2021, it is directed that the period from 15/3/2020 till 28/2/2020 shall stand excluded for the purpose of limitation as may prescribed under any general or special law in respect of judicial or quasi-judicial proceeding. Now, my lord, the order was passed on my lord 2/2/2022, my lord. So, my lord, till 28/2/2022, my lord, there will be no limitation, my lord. Limitation will be counted from 1st of March, my lord. And lordship may see paragraph 3, page 130, my lord. In cases where limitation would have expired during the period 18/3/2022 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1st of March 2022. In the event any actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply. My lord, my contention is that, my lord, I am entitled for 90 days from 1st of March, my lord. And if the limitation is counted from 1st of March, my lord, my appeal is within time, my lord. It was filed, my lord, on 27th of May, my lord.
Your limitation expires when?
My lord, the counting will start from 1st of March, my lord, because, my lord, order.
Had this order not been there,
my lord,
when would your limitation would have expired?
Would have expired, my lord. It would have expired on 12th of May, my lord. 12th of April, without condonation, with condonation, 12th of May, my lord.
Of 2022.
2022, my lord. If this order would not have been there, my lord.
Yes, Mr. K.
Lordship, paragraph 13 is clear. Lordship, the Supreme Court judgment was taken into consideration.
No, but from
Even
the,
if-
from the
even if-
dates which are given,
Okay.
from the dates which are given, show,
Yes, sir.
it says para 13
Yes, Lordship, it has been quoted here in paragraph
would have expired on 12/4.
12.4. Then they filed appeal on 27/5/2022.
Hmm.
It should have been filed on 12/5.
No, in case of, in page number 130,
Then
there is a further limitation for 30 days. Sorry, 90 days.
Yes,
From
but
1/3. So 1/3, 90 days will be
that is-
1415.
see, that has been quoted. Lordship, here, the question of interpretation will come.
What interpretation?
Lordship, that has been explained in paragraph 13, page
No,
1.
first, let us understand in case of serial number 3 at page 130.
My lord.
What is the maximum period that you have?
I would have 90 days, my lord, maximum.
No, 90 days from 1st of March.
1st of March, my lord.
Which will expire when?
On 29th of May, my lord, if 90 days is counted, my lord, because
29th of May.
my lord, 31st, in the month of March, my 31 days there, then April 30, then my lord, 29th of May, it will be, my lord.
So 29th of May, apparently.
No, Lordship, let me come to page 141.
Yes.
Lordship, paragraph 13, I am again reading. Going by the above mentioned, serial number 3 of the section 85 of the period of 2 months from the instant case would expired on 12/4/2022, where the appeal has been filed on 27/5/2022. Even as 1 month has extension of the Commissioner's appeal can allow for expiry on 12/5/2022. Further, I examine the delay in terms of judgment of Honorable Supreme Court in Somoto, writ petition number 24, dated 10/1, which has been referred by my learned friend. Wherein in paragraph 3, it has been ordered that in case where the limitation would have expired during the period between 15/3/2022 20 till 28/2/2022. Dr. Lordship, the limitation expired is
So it is only for those cases where limitation could otherwise expire prior to 28.
yes, 28 within 28/2/2022. Then Lordship, they will. Lordship, even the interpretation of the authority may be, suppose for the argument's sake it is wrong. Provision of appeal is there. They can place all these things before the learned session law.
But my lord, appellate authority is not read para 1, my lord, of Sumoto order, my lord, which says it will exclude, my lord. That period will be excluded for a purpose of limitation. From 15 March 2020 till 28th of 2020, it will be excluded, my lord.
No. So you are filing an appeal. You are filing. When was the original order passed?
Original order was passed on 2/2/2022, my lord.
2/2.
No, Lordship. Appellate order 31/7/23.
No. Original order.
Original order, Lordship.
02/02/2022.
2022.
Page 104, my lord.
So what is the period for appeal?
My lord, from date of communication, my lord, 2 months,
2 months, 60 days.
60 days.
So it would be 4th of 3rd of April.
My lord,
Sorry.
from the date of communication, it will be 12th of, my lord.
12/4.
It was
12/4.
12/4, my lord. 12/4.
So you should have filed an appeal within 12.
My lord, if,
Within 12.
my lord,
Now the period excluded from 15/3/2022 to 28/2/2022.
my lord.
Doesn't affect you because
No, my, but if I will count my limits, my lord.
you will get till 28/2/2022.
My lord.
So you'll get about 26 days.
My lord, around 26 days.
26 days. So 26 days means a 27th or
my lord,
27th of April, May.
May. And I filed on 27th of May. In that way also, my lord, perhaps, my lord, I will be covered, my lord. Lord, similar order, I am relying upon, my lord, in similar case, my lord, coordinate benches passed some order. Let us cite, my lord, paragraph 3, my lord. But even if, my lord, Lordship may remand it for hearing the matter on merit, my lord.
Para 3.
My lord.
Para 3.
Para
No,
3.
you give us the dates.
Well, dates I am giving, my lord. Date, order was passed on 2nd of February.
Where have you stated in the body of the writ petition? Is it there?
Yes, my lord. The order of annexed 104 is the order, my lord.
Have you stated in any paragraph?
My lord. Paragraph 18 I have explained, my lord.
Paragraph?
18, page 15, my lord.
18, yes. I think, Mr. Kyal, it appears to be within limitation.
No, Lordship, there is a promoter order, Lordship, which comes to clause 1 and clause 3.
See, there is no dispute that the period from 15/3 to 28/2 is excluded.
But in paragraph 3, page 130.
Yeah.
In case where the limitation would have expired during the period.
No, we are not on this. We are only on the first paragraph.
No, Lordship, because this is also part of that order. That was taken into consideration by the appellate authority while considering the application of.
No. This is not applicable to him. Para 3. Is Para 3 applicable to him?
Obviously, Lordship, in fact, Lordship, there is a contradiction between clause 1 and 3.
No. The clause 1 says 15/3/2020 to 28/2/2020.
It is right that the period from 15/3/20 shall be
Excluded.
excluded for the purpose of limitation is the it may be prescribed under
So
general
therefore,
or special
the
law.
order in original was passed on 2nd of February.
Yes, sir.
So he'll get a benefit till 28/2, which is excluded by the order of the Supreme Court.
But if we go by the clause 3, then the interpretation may be different.
How?
Because here
He
said that
gets an order.
if the period of limitation is expired between 15/3/2020 till 28/2020.
No, here the limitation does not expire. It expires after 30 days, isn't it? What is the period for appeal? 30.
60 days. 60 days plus
60 days.
60 days.
60 days.
60 days.
So from, let us say from second, let us say it is from second of February.
It was there.
Or 12th of February.
12th of April.
When was the order received?
12th of February, madam.
12th of February.
Then 12th
From 12th of February, 60 days.
60 days, 12th.
12 or 13 or 14, whatever date it is.
Yeah.
Right? Now, above that, he gets
30 days.
from 12 to 28. Another 3 more days he'll get.
No, here my explanation. At the clause 3, if the period of limitation expired between 15/3/2020 till 28/2022, here if their limitation expired on 12/4. So after 28/2.
That's right. So therefore, he doesn't get the benefit of clause 3.
Yes.
But what about clause 1? Entire block has been
That
excluded.
That is my humble submission, because there is some we interpreted if we read together 1 and 3.
How? Firstly, that benefit is given to it. It is to be then extended period of limitation. Supposing your let us say your order was passed on 2nd February. You'll get the benefit of limitation till 28 February.
No, that is correct. But here their limitation.
So you're counting, even if it is from 2nd February till 2nd of April, that additional 26 days will have to be given to him.
If separately we interpret clause 1, then Lordship probably he
That
will.
is how it is to be interpreted. How else it is to be interpreted?
When we read clause 1 and 3, then probably
No. 3 is for where there is a limitation period which expired within that period. Then you get another 90 days.
Yes, that is correct. But here
Here it does not expire. So clause 3 is out.
No, look, because the order was passed on 2nd of February, and they get 60 days for filing appeal, and another 1 month. That means 12/5. So it is,
How
1 month is prescribed under the law. So their limitation expires on 12/5 after 28. This is my humble sentence. This is my sentence.
So what will happen to the benefit of 28?
Because
your order was passed. See, otherwise,
No, that is
you'll have to count from 12/2. You'll have to count the limitation from 12/2, namely the date when the order was received.
that is the interpretation taken by the authorities.
I don't know, but whether you can do it in the face of this order saying that it stands excluded.
This point was for consideration before the learned judge who passed the order also. This was also for the reason because there is a contradiction between 1 and 3. And since there is no authority on
There
the.
is no contradiction according to me. One is that if a benefit
Yes,
limitation being 28.
Then Lordship, there is no dispute. But
And 3 is where your
Limitation
limitation expires.
Yes.
Then you get further benefit of 90 days. Limitation expires within that 28. But even if your limitation does not expire, the residual amount till 28 will have to be given to it. As per clause 1.
Separately, if we consider, then Lordship,
Has to be considered separately.
my submission may be recorded.
Your submission is that since this limitation was beyond 28,
yes,
he is not entitled to benefit under 1 and 2.
Yes.
That's it.
Yes.
But you are disputing the submission that 1 on its own cannot be granted the benefit. It must be read with 3 also.
Yes, sir.
That your submission.
Yes, this is.
But primarily it appears that the benefit of 1 is to be given. Both are
That is
mutually exclusive.
That is
Hard learned counsel to the parties. It's aggrieved by the order in original 31/7. Commissioner appeals PPST stuff. July is the beat for the time bar
My lord.
and dismissed. So the appeal was directed against the order in original passed by the Assistant Commissioner of GST and Central Excise Ruga dated 2/2022. So done at Council for the Commissioner submit and in view of the order
127, my lord.
dated 10th of January 2022, passed by the Apex Court in miscellaneous application number 2022, page 127. The benefit of limitation as per clause 1, Roman 1 of that contract, of that order, was not given to the writ petition. And the appellate authority wrongly interpreted the provision and dismissed the appeal as holding it to the time bar. So, he therefore approaches this court praying for a that Mr. SCF, standing counsel against the respondent submits that clause 1 and clause 3 of the order dated 10th of January 2022 passed by the Apex Court has to be read together. And if done, then the period of limitation in respect to the writ petition expired after 28 to 2022. And therefore, he is not entitled to any benefit of extension of limitation and the impugned order and the order of the appellate tribunal impugning the present writ petition does not operate. Having heard that prima facie this court is of the view that the benefit of the directions contained in clause 1 in the order dated 10th of January 2022 passed by the Apex Court appears to be available in the writ petition, in which case the period of limitation in respect of preparing an appeal for the appellate authority would have expired on
12th of May, my lord.
on 12th of May.
Sorry, my lord. It not be after excluding that part, my it would be, my lord, 27th around.
Period interpretation of the so and so appears prima facie appears that the petitioner's appeal was not time barred. Accordingly, let notice be issued return respondents file their response and be listed after the return of the date. Particular matters are fixed on 22nd of July.
It is not similar, my lord.
Then the matter be listed again on 24th of July.
Can it be, my lord?
The dispute order passed by the appellate authority as well as the order
Deeply obliged. Well, can you go 25th, my lord, if lordship allows 25th?
26th.
Deeply obliged, my lord.
May I please a lot? Lordship, in this case, Lordship, we have challenged the cancellation of registration. I have filed an appeal that was also rejected on the ground of delay. Lordship, my ground for Lordship cancellation, Lordship, may kindly see at page 69. The so-called notice which was issued. Lordship, Lordship only.
Gogoi, any information?
No.
No information.
No.
Page
No,
69.
this is the first time it has come up.
This is
No, there was an earlier matter also.
It will come tomorrow, Lordship.
But that matter, they were supposed to furnish some notification, which has been recent decision of the matter.
The GST council meeting, I have given Lordship.
What does it say?
Lordship, Lordship, in this case, it will not be applicable, but I will place this for the other case. Lordship, the recommendation, Lordship, the first recommendation itself for 17, 18, 18, 19, 19, 20. I'll give you the copy. Let me read. First recommendation. Lordship, the first recommendation says GST Council recommends waiving interest and penalties for demand notices issued under Section 73 of CGST Act for the fiscal year 17, 18, 18, 19, 19, 20, full tax demand is paid. So if I pay up to 2025, all tax, interest and penalty is waived.
But nothing to do with.
Yeah, the registration.
Yes, sir.
This is about registration.
Registration, I was just only that
Your registration was cancelled. It's
cancelled.
not
I
about,
was ready to pay the demand, but I was just
that's a different
contemplating.
issue, but it's not about penalties or demand notices.
Yes, sir.
Lordship, counsel for the
Lordship, if Lordship may kindly, if you Lordship may allow, this is a bit different, Lordship. Only one page I will show you, Lordship. Page 69.
69.
Yes, your Lordship. Lordship, the so-called notice says the so-called notice says the Lordship. The reason is in the second paragraph. In case of voluntary registration, non-commencement of business taxpayer within 6 months from the date of registration. So they are saying that you have not commenced your business from 6 months from the date of registration. That is why they have cancelled. Lordship, my registration was from 6/10/2017. Thereafter, Lordship, so far as 17, 18 and 18, 19 are concerned, they have raised demands on me. If I'm not doing business, how the demands are raised? 17, 19, 18, 19. Lordship, the demand orders I have annexed.
demand for what?
Lordship, the one is excess claim of ITC. There is interest. Tax payment has been done. Lordship, my registration is at page 31 and Lordship, my demand is at 34. 34 is the so-called notice for 17, 18. And the demand is at page 41.
They've already passed order.
Yes, your Lordship. Page 41 is the
These are not
DRC.
on the challenge.
Lordship, this they will take its own course. I'm not challenging so far as this stage petition. I'm only concerned about the cancellation, Lordship. Page 41, Lordship, will keep the July 2017-18 excess ITC claim. So if I'm not commencing business, how is 17-18? Lordship, again for 18-19. Lordship, Lordship, I've got the page 41, 17-18 excess ITC claim. Then Lordship, page 46 is 18-19 order, demand order. This is the so-called notice, Lordship, that will be adjudicated for 18-19.
No, page 41 is the summary order.
This is the final order, Lordship. DRC 7 is the final order. And
essentially, when we cancel the order dated 19/12/2019. Proposed notice and the order dated
31/12.
Proposed notice dated 19/12/2019 and the order dated 31/12/2019. That the GST registration for registration has been cancelled for non-commencement of business of the taxpayer within a period of 6 months from the date of registration. That is not a correct statement, as the department has already issued proposed notice and passed summary order for on the petitioner for claiming excess ITC. Submitted that if the petitioner had claimed excess ITC, that by itself is evidence of the fact that the petitioner was in business. Therefore, the ground for cancellation of the inspection. And there will be no appellate authority. There is no appeal. There will be no appellate authority. The Act doesn't pray. All this.
No, my lord, 1 and 2 is central government. I am appearing for 3 to 5.
3 to 5. MS A. Sharma appeared for respondent submit that they will obtain instruction. According to the notice, we should return after 4 weeks. That's it.
But
Yes,
a fixed
sir.
date may be given, but Lordship, this will be disposed of.
Fixed date.
Otherwise,
24th,
yes, Your Lordship.
24th July.
Okay.
Since standing council have already entered appearances,
No, let it be on my lord 31st.
notices are
At least
waived.
4 weeks will be
except
over there.
in a period of 1. You want it on
31st?
31st?
After 4 weeks.
After 4 weeks.
Yeah.
Then we'll have it on
2nd of August.
2nd of August.
March.
My trouble.
Your Lordship. Lordship, Your Lordship, to protect the national highways, Your Lordship, guide banks were constructed, Your Lordship. And in this process, Your Lordship, lands were acquired, Your Lordship, those lands were acquired, Your Lordship. The compensation for house and giraffe were granted. Your Lordship, what happened, Your Lordship? Since my house and giraffes fell under the guide band, Your Lordship, my APR form for payment this form is filled up because of as data for electronic payment, Your Lordship. And thereafter, Your Lordship, respondent number 8 approved my form. And Your Lordship, thereafter, Your Lordship, I didn't receive compensation. When I didn't receive compensation, I inquired. Then I came across the list of beneficiaries, which is at page 19. And I have come to know, Your Lordship, a person with identical name, Your Lordship, he has been granted compensation. And Your Lordship, his name is on serial number 17. But it is to be noted, Your Lordship, like other beneficiaries where along with their name, Your Lordship, their father name is also enlisted. In this case, his father name is not mentioned, Your Lordship. And Your Lordship, his father has also received compensation, and his father's name is on serial number 18, Your Lordship. Thereafter, Your Lordship, I have filed a complaint case, Your Lordship, before the JMFC Sunitpur Tejpur, Your Lordship. The JMFC Sunitpur Tejpur, Your Lordship, by order dated, Your Lordship will find on page 29, annexure 4, Your Lordship, has remanded the matter to the OC of police, Jammuguiri Police Station, OC Police Station, Your Lordship, but nothing has been done. I have been visiting the police station. They are not cooperating. Yes, Your Lordship.
3, 4, 6, and 9.
3, 4, 6, and 9. And Dharpura for respondent number 1, 2, 5. Steps on respondent number 7, 8, and 10. By using code registered. Respondents are at liberty to complete their it's after return.
Your Lordship, till returnable date, Your Lordship, the compensation which are left should not be, Your Lordship, released with regard to respondent number 10, Your Lordship.
Not without notice. Let them be on notice.
May it please the Lordship, the petition is and the duly licensed stamp vendors for the district and engaged in the occupation of distribution of sale of division and in the physical form. By the order dated government notification date 23/6/2003, the government discontinued the sale of physical of non-judicial stamps. Therefore, the petitioners apply for empanelling them.
Notice that is heard. Returnable 4 weeks. SHRI appears for
2, 3, 4, 5, and 7.
3, 4, 5, and 7.
Oh, my lord, I'm sorry.
On to for respondent 1.
2
1
and 3.
1 and 4.
2 and 3.
3. So you are appearing for 1, 1 and 4. 1, 4, and 5 also.
5.
Mr. B. Gugoi for respondent number 6. Steps on respondent 7. I registered 1 week. And will be listed after the other councils are at liberty. Respondents are at liberty to complete their instruction. File necessary action. Yes, Mr. Patel.
My lord, I have challenged the order dated 17/4/2014, passed under section 148A D of the Income Tax Act, as well as the notice under section 148 of the Income Tax Act. Now, my lord, first of all, I am taking to
Order has been passed, reopened. Your assessment has been reopened.
not reopen. What has happened in this particular case, I claim that deduction pursuant to the section 80
Show us which order is under challenge.
both the orders, my lord, at page 50, my lord, and 58. Your lordship will see
Yeah.
your lordship may come to page 53, my lord. The reason of opening of it.
So your objections were rejected.
My objection was rejected, and after that, this order has been passed. At page 53, my lord, since deduction under section 80I of the Act is allowed for a period of 10 years, the SSC company is eligible for deduction of section 80 for the year 2009-10 to year 2018-19. Therefore, claim of deduction of section 80 for the assessment year is inadmissible. That is the thing, my lord. In this particular case, my lord, what has happened, that no doubt, originally the commercial production was started on 1/8.
We'll examine the matter. Your grounds are yes, Mr. K.
Lordship, here only notice has been issued directing them to file return. Alternative remedy is available to them if the final order is passed.
Alternative after filing. After the order is passed.
Lordship, may please come to page 57.
Have you filed your return?
No. They're challenging this.
Because that's why, because I have challenged. It is without jurisdiction so far. Both the notices are concerned, those are without jurisdiction.
Counsel appearing for the petitioner, Mr. HCL, appearing for the Income Tax Department. Petitioner Kelly, the notices under section 148 and proceedings under 147 the Income Tax Act. Pursuant to the notice issued by the department, filed their objections, which came to be rejected, and notice under 148, the income tax has been issued. And the concerned income tax officer has to assess or reassess the income or recompute loss or the depreciation allowance or any other allowance deduction the assessment year 2020 -21. So the petitioner was asked to file the returns for the assessment year 2020 and 20. This order is contrary to the law as reasons furnished.
Yes, sir, I have furnished the reason.
No.
That is the
Department.
objection.
Department.
Reason I have not furnished.
Reasons
Still
has been
the time
provided.
is there. That's why my lord is.
No.
Reason.
Reasons for
Reasons for
reopening the assessment. Did you ask for it? Was it furnished to you?
Pardon, my lord.
For reopening this process, the process of 147, 148,
yes,
the authority, authority is bound to give you its justifications for proceeding for reopening.
My lord, here after issuance of the notice in section 48, that is
he submits that the grounds for reopening the assessment procedure prescribed in the Income Tax Act not followed, and there is no material proceed for reopening of the assessment. Therefore, approach this court for filing. Mr. SDL studying out that the matter gets proceeded, there is adequate remedy for the petition to file proper appeal before the Commissioner of Appeal once any order adverse to the petition is passed. At this stage, no interim order that will. I think that is it.
My lord, so far the interim order is concerned, may I be heard?
You don't want?
No, may I be heard? So far the interim order, because so far the old notices have been issued under section 148 8D as well as 148 are without jurisdiction. Why those are without jurisdiction?
We'll hear the matter. Let them
No,
file.
yes, my lord. Till then, my lord, next day, the stay may kindly be granted.
Day of what?
Or of this notice, 148.
That matter will be listed on the 2nd of August. Further proceedings, the so shall remain state the next 8 days. Yes. I will escape upon appears for responsible party.
Petitioner in the year 2001 to purchase the land measuring 14 lakhs. But thereupon the DUG number was wrongly written, so we have filed an application for correction of the DUG number. Instead of DUG number 111, instead of DUG number 107, it was written as 111. Now, all through the proceedings, my lord, the petitioner was, my lord, your lordship will kindly see page 40. Others are there, I'm showing page 40. 48%, 48.
48.
Yes. This is by the Latmandal to circle officer. Last page, my lord. Based on the field verification conducted in presence of the parties, their proportionate share of the land measuring 1/13 lakhs of DUG number 107 under possession is shown below. My lord, petitioner's name is in page 49, Amrit Chandra Bola. It is in respect of 5.5 lakhs of land that will go for acquisition. And your lordship will kindly see page 40 now. This was because they could not finalize the land acquisition value. The matter was sent to the additional district judge, page 40, to the district and session judge under the NHA Act. And below, my lord, petitioner name is there, Amrit Chandra Bola.
Yes.
Now the learned additional district judge has passed an order at page 41 without hearing me.
Where is that? Page 40.
Page 41. I was not heard, others were heard.
Any appeal?
There is no provision for filing. My lord, this is an order, my lord, without hearing me, without this. My lord, all throughout the proceedings, my lord, I was heard. So therefore, the compensation amount, my lord, determined in respect of.
Why were you not heard? You were not made a party.
But others were heard. I was not heard, my lord. I didn't even know. Your lordship will tell me that page 40 matter referred to the district judge because they could not determine the compensation. So district judge, my lord, while writing the concerned parties.
But did you receive any notice?
No, we did not receive.
Mr. Hendrik, you'll have to update it.
Lordship.
But hello.
Two and three, Lordship.
That is the owner of 5.5 acres.
That number 107.
Where are the particulars?
Particulars I'll give you.
Page number?
I'll provide.
Page 24.
Page
24.
24.
The schedule of the land, my lord, sale deed.
That is the sale deed, but here Doug number is wrongly written. Instead of 111.
That is
it will be
111. That's why, my lord,
We are in
it is-
possession of the land since 2001.
No. What is the schedule?
Schedule is this, but it is in respect of Doug number 107.
According
land was, my lord, acquired.
according to the petitioner, it's covered by doc number 107
Yes.
of periodic patta
Purity Patta 112, lord.
112.
Your lordship will get it at page 48. ma'am. Period patta number 112 located at Sangli village has been acquired for 4-lane bridge.
uh, periodic patta 112 at located at Chengeli village.
Yes.
Which was required for 4-lane for the construction of 4-lane national highway. So the petitioner, along with other co-partners, were required to be paid the compensation. However, the compensation of the determined and record the district judge GAUHATI under the provisions of the National Highway Act. The district judge, additional district judge GAUHATI, by order dated 28th of March 2024 in land acquisition reference 30 of 2022 decided the matter. However, the petitioner, although was served notice, not heard in the matter. Being aggrieved, he is approached his court. The heard learned counsel for the party with his return of 4 weeks. Mr. They handing it to you on behalf of the court number
2 and 3, lord.
2 and 3. Since the respondents are permitted to complete their instructions. Notice on any interim prayers.
The compensation should not be disbursed in respect of the petitioner, in respect of the 5.5 acres of land.
Notice on the interim prayer. The competent authority did not disperse compensation in respect of 5.5 acres of land covered by so tag number, patta number 20.
Covered by Doug number 107, periodic patta number 1.
According to the petition, belongs and is under his possession. So, that will be declared on 2nd of August.
Obliged.